I have a gentleman I'm really excited to represent. We're going to trial in his case very, very soon. And some of the things he said on the 911 call are like, oh boy, oh boy, oh boy, there are jurors who are not going to like some of those words you used. So, no, hard no.
We are the Armed Attorneys. Today we're talking about your questions that you've asked. These are some good ones. Citizen's arrest, keeping a body-worn camera on your nightstand next to your bedtime gun.
Ooh la la.
Spousal privilege. This came up a little bit. And let's say you have a church inside of a school. Is it no longer a school? We're going to be talking about all this and more. But before we begin, show your support for the Second Amendment by hitting that like button. And join us over on armedattorneys.com. We have the Armed Attorneys Insider newsletter. Just type in your email. We send out newsletters periodically. Get on that list. You don't want to miss those breaking updates. Emily Taylor, good to see you.
Well, thank you. So happy to be here.
Yes, and these are our most fun segments because we're answering your questions. We kind of took a poll last time about whether we should reveal people's handles or not, and it seems like everybody voted. The people have spoken. The handles are staying for the time being. Don't ask anything incriminating, though, guys, because that's what the concern is.
Yes. You can ask a very specific hypothetical.
Yeah, dates, locations. Don't do any of that stuff, all right? All right, the first one is to you, Emily. This is from Steve Burrows, 4709. Question: what are your thoughts regarding school firearms prohibition as applied to a church that during the week hosts as a tenant a small charter school or a portion of their campus? To what extent would this prohibition apply? How would the school provide for persons being able to carry, such as clergy, ordained church officials, as they conduct church ministry while the school is in session? And so I did want to add a little twist to this. Church hosting school versus school hosting church. Yeah.
Right. So this is church hosting school. So wherever you live, you are going to likely, with 99.9% certainty, have a definition of school in your codes. You need to find this. You need to know what it is. They vary wildly. Richard and I used to have to look this up for the purposes of gun law all over the country. They all are very, very different. That definition will certainly control. Let's talk about Texas. So in Texas, our definition is for your school is a school is a school is a school is a school. And that is for your public schools, your private schools, your parochial schools. Now, that is ISD property is always going to be a school. And if a school is in session, it is a school. Now you have these weird gray area issues in which it's a church. Church has a school. Well, which one holds? It's not ISD property, but a school is a school is a school is a school. And ultimately, we're going to tell you that the portion that is a school when the school is in session, certainly. It might always be a school, depending on how you are laid out. Now, is the entire building a school during school hours, even the portion that's just the church? Maybe. It's up to a jury. If you want to be extraordinarily safe in the state of Texas and you need to carry into that location, get permission from the pastor or the highest governing authority of the church, specific to you in writing with your name on it, that says that you can carry a firearm in the premises. That is your exception. However, just know, and there's likely lots of gray area in your state if you're not in Texas, based upon your statutes when you have this kind of situation. Just know it gets murky and gray, and you got to figure out what's a school, what's not, what's a church, what's not, and how do they interact in terms of your carry. It's complicated. If you're in Texas, though, you got that cut out.
Yeah, and I would say one more potentially is we clarified the location of a school-sponsored activity. Mm-hmm. So if the school was leaving their ISD property and renting some other space, we know that prohibition is not going to apply there. And that's just for Texas because we specified school-sponsored activity in an area or location owned and under the control of the school. So if it doesn't check all three of those boxes, then we know it doesn't apply.
Yep. All right, now we've got at Old Man Mark 9548. Question for future video.
I like it.
Terrible advice on my Nextdoor app. Oh, this has and your neighborhood Facebook page. Their self-defense advice is so bad.
Yeah.
Topic of citizen's arrest. Example, saw someone walking with a dog on a leash before sunrise. He had a flashlight. I think he's checking for unlocked cars and casing houses. Not going to call the police because the last 14 times they didn't show up for hours. Response to the post was, get your gun, make a citizen's arrest, drive him to the sheriff's office. Second example, this is the first time I'm reading through this. We often surprise each other with questions, and my eyeballs right now are so big. Okay, second example. Kids walking home from school rattle my fence and upset my dogs. Response, make a citizen's arrest, drive him to the sheriff's office. Is it better to leave the arrest to those who have qualified immunity?
Wow, this person on Nextdoor app, their answer is always, drive him to the sheriff's department.
Wow, wild. All right, go on, Richard.
Well, my first impression is, yeah, they probably stopped responding after 14 times. You know, you call them that frequently. Maybe the police aren't taking the boy who cried wolf seriously anymore. But ultimately, citizen's arrest, generally, I'll say, not a very good idea. And why do we say that? Well, because we're talking about a use of force most of the time. When you're restraining someone, it's a use of force, so it's not deadly force. It can be, though. But what makes this so precarious is for, self-defense or justified use of force, it has to be reasonable, immediately necessary, and then proportional, or, your level of force has to kind of match their threat of unlawful force. And what makes these arrests so difficult is this immediate necessity. Well, as soon as this person's not a threat anymore, your continued restraint of a person might probably be considered unreasonable because it's no longer immediately necessary. They're not a threat to anybody anymore. So these citizen's arrest situations, I try to avoid them like the plague. Call the police. You're not the police. And why? The other thing is you're just exposing yourself to all kinds of liability. Have you seen citizens
criminal and civil?
Yeah, and we'll get to the fence example in a second, but have you ever seen a citizen's arrest go well?
No.
I've never seen one go well. So, and that's telling you, we've seen a lot of this stuff. It doesn't go well. All right, the second one of rattling a fence, citizen's arrest. Think about what level of force would you be justified in using against someone rattling and startling your dogs? Probably very little force, if no force at all. So, would a citizen's arrest be driving to the sheriff's department? Good idea? No, I can confidently say that's not a good idea.
Yeah, no, and everyone's state law will vary in terms of what allows a citizen's arrest. Is it you personally witness a breach of the peace or a felony? Is it something more than that? Is it something less? Either way, these are someone's walking with a flashlight or rattling your fence. Someone, breaks into your home and you hold them at gunpoint till the police arrives. Sure.
Yeah.
That's fine. Citizen arrest that all you want. But these are scenarios in which, you're suspicious, but your suspicion will ultimately get you charged with the crime.
Yeah,
so.
Just to give a little example, and I know this is going to make all my security guards here in Texas really mad, but like security guards in the state of Texas do not have general arrest authority, and they have to rely on our citizen's arrest statute. And I can't tell you how many security guard clients we've had who have restrained people who were in the middle of legitimate, criminal activity. And the police, well, first off, they don't like security guards. No. That's a whole nother video. But this continued restraint of a person, that's always the argument that gets made. So just want to bring that up. All right, Emily, this one to you. Shibosuru. Question. I was told by my CCW instructor that if you defend yourself by putting someone in a wrist lock, you'd be charged with false imprisonment. Is that actually something a prosecutor would do? FYI, I'm in New Mexico.
Well, first of all, if you're in New Mexico, all bets are off. I'm sorry. The more, and it's amazing to me because New Mexico should not be an anti-gun state, but of course now that is the world that you all are living in. The more anti-gun your state is, the more anti-self-defense your state is going to be, and the more likely a prosecutor will in fact charge you, whether or not it's a good charge. And, frankly, as I'm not a New Mexico lawyer, I can't tell you whether, what a wrist lock is going to get you in terms of your self-defense, because I don't know what the police, that's, and general self-defense principles will apply, but that doesn't stop you from getting arrested.
Well, I was going to say, and it piggybacks on the last question just a little bit, but what level of force would you say a wrist lock would be?
Well, it's just force.
Yeah, so it wouldn't be deadly force, and so then it goes towards, what level of force would you be justified in using?
Right, and for how long?
Yes.
And what is reasonable. So, but yes, will it get you arrested? You would hope not. You would always hope not. However, you have to think more about, I would say more than what the law is, you have to think about where are you? What are the political pressures on the police and the prosecutor's offices? Because that's going to tell you, because ultimately your question is this something a prosecutor would actually do?
The answer is yes.
Yeah, big time. All right, we have at John Galtman. Question, I thought a spouse had the ability to not incriminate the person they are married to. Why would they have to leave if you're talking to your lawyer? So this is...
And it kind of piggybacks on that.
Yeah, so this is, it looks like you guys did this without me here. At Mike St. John, do 5U. If you don't want your info disclosed, don't ask questions. Edwin asked the wife to leave the room. What about spousal privilege? So what happened?
Yeah, so context here, we were talking about protecting attorney-client privilege and why it's so important that you communicate through an attorney and how to maintain attorney-client privilege. Edwin gave an example of he was speaking to a client, wife was present, he asked her to leave to maintain the attorney-client privilege. Now here's the rub, and I can't say that I've ever seen this happen, but when the attorney-client privilege, that's between the attorney and the client, if there's a third person there, well, okay, they could be compelled to testify, no attorney-client privilege there. Theoretically, the court could compel the attorney to testify. Now, I haven't seen that. I can't imagine a court doing that. That seems kind of beyond reproach. But theoretically, the attorney knows, hey, this wasn't a privileged conversation.
Well, and the wife could be compelled to testify because it wasn't something her husband's,
Right. Yes, exactly.
I mean, yeah, she can say what the attorney said all day long.
She can say what the attorney said.
Yeah.
Now, can she say what her husband told the attorney? Now, that's where spousal privilege comes in. Your spouses cannot be compelled to testify of what what your spouse told you. However, they have the option to waive that privilege. So attorneys, for example, don't have the option to waive that privilege. Spouses, if they say, I really am fed up with my husband, he shouldn't have done this, and wants to testify, if the husband wanted to invoke the spousal privilege, it's really not up to him, it's up to the wife.
Yeah, I really hate issues of privilege. Do you remember I had that really crazy client? I had that woman who was accused of a bedroom assault. Do you remember?
Yes.
Women aren't often accused of bedroom assaults. I'm using the words that aren't going to get us demonetized on YouTube.
Bedroom assault at gunpoint.
Bedroom assault at gunpoint. And she would come in to meet with me every time with like a gaggle of what I can only describe as emotional support betches. Do you remember that? And I would always have to be like, thank you, betches. Goodbye. Leave the room, please. I have to speak to my client. And they would get so angry. But it's like, those women could be subpoenaed to testify.
Yeah.
And say everything that we said. So it's like, come on, dog.
And there was a good outcome on that case.
Better than she deserved, if I'm being honest.
Well, we'll see. These people have a habit of finding an orbit around you. If you love something, you let it go. If it loves you, it comes back.
Oh, God bless. Don't say that.
All right, this one to you, Emily. All right, next one is from Fireman Jeff. Good to see you, Fireman Jeff. We've had your questions before. Here's $1. Thank you, Saul Goodman. Love that. When police started wearing body cameras, wasn't it intended to show all the brutality and crooked cops, but has only shown most officers acting in self-defense in split seconds, seeing things that some bystanders don't see?
This is true.
Yeah, my question, when I grab my nightstand defensive weapon for those bumps in the night, should I also slip on a GoPro or similar device? That way you can prove the home invader had a weapon or was 100% inside my house, etc.
Okay.
It's an interesting question.
When, at the beginning of the show, when you said GoPro camera on the nightstand, I wasn't thinking about it. I was thinking it was like you were like letting it go all the time, like letting your camera run just in case someone broke in at night, which
No.
Like, I mean, if you're going to bedroom assault someone at gunpoint, you should definitely not have one of those.
That's called a callback.
But no. So, look, no, hard no. Here's why. Because if someone has broken into your home, you are in the right. You do not need to manufacture evidence that could, because I love, with few exceptions, and we generally talk more about the exceptions than the rule on this channel, I love my clients. I get to represent some of the best human beings. And yes, my orbit around them revolves some of the worst days of their lives, but they are good people. And yet, good people do and say stupid things in the moments just before and after they have to shoot someone. I have a gentleman I'm really excited to represent. We're going to trial in his case very, very soon. And some of the things he said on the 911 call are like, oh boy, there are jurors who are not going to like some of those words you used. So, no, hard no. There is nothing that can happen in the privacy of your own home that would necessitate you creating evidence to show you did the right thing. Someone breaks into your house, shoot them up. you're probably going to be okay. Don't let it be your son-in-law. Those are the cases I've had that have not turned out as well. Don't create that evidence. But let's change the scenario. Something out in public. What do you think?
Well, and I would say, tongue-in-cheek stuff aside, the thing that jumped out at me before we go out into public is it undermines immediacy. If you have time to strap on a body-worn camera before you go and, confront the threat or whatever, I think that undermines immediacy a little bit.
I feel like I could throw a GoPro around my neck and hit the button and it not undermine my immediacy.
Or if you had one of those harnesses, like, what was that movie? The Blair Witch Project or whatever, where it's just like, what was the movie where they wore harnesses and it just captured their facial reactions?
I guess Blair Witch?
I don't know, whatever.
Yeah.
But I don't,
a long time.
I can't imagine that being super, super useful. Let's say out in public, though. Body-worn cameras. I've seen a couple of these on clients. Can't say that I hate them. They capture, and I think we say this probably too often, captures reasonable people doing reasonable things and unreasonable people doing unreasonable things. So it's like a firearm. It's a tool.
Mm-hmm. And this is where Richard and I differ, because I knew Richard was going to say he's pro-camera in public. I am generally anti-camera. I will say, as a trial attorney, I think that one of my greatest skills is painting a picture of what you did that is so much more beautiful than what that camera could show. The camera can be picked apart second by second by second by second. My words are it's beautiful. Like, you can't tear it apart. It just flows in a way. I mean, the canvas is just coated with my
Emily doesn't think very highly.
Words.
You should give yourself some credit.
Well, anyway, but but look at us. We both do this for a living. Reasonable minds can differ. Not necessary on your nightstand. Is it something you want to implement in public? Possibly. Do not let the police see it until your lawyer has reviewed it.
Well, what we'll say, though, what a lot of the camera manufacturers do now, especially if they integrate with an alarm system, is if you have it set to where there should not be any entries and it enters and the cameras switch on, that maybe is a little bit of a better thing. Doesn't undermine immediacy, but probably you don't want that stuff in your bedroom. You probably want it in areas where you're going to
maybe you do.
Yeah, maybe you want it front door or whatever. And you're so
Richard thinks I'm gross.
We hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please, question, comment for us below. Go to armedattorneys.com. Sign up for our newsletter. We will not spam you. I promise. It is just the news you need to know when you need to know it. Until next time, we're the Armed Attorneys.